Octogony and Grant Thornton share, or at least shared, at the start of the case, common partners and the same lawyer, Ferdinand Berg. How would you describe this situation?
To me, Octagon and Grant Thornton are practically the same thing. You have former partners and current partners from the group of 8 who are currently at Grant Thornton or originally came from Grant Thornton. And on the other side, you have Octagon, which is comprised of the exact same people at Octagon, sharing the same lawyers, the same interests, and working in close coordination against us. That is to say, for me, even if legally perhaps, they could consider it to be different. For me, they are essentially one and the same. Especially a firm like Grant Thornton, which should understand governance. And here, what we can ask ourselves, the very least of it, is an absolute conflict of interest between investors, the same people who are advisors, auditors, potential central administration, and who, on the other side, are also tenants. And here, they are on the board of directors. It means that today, the situation is such that this overlap makes them one and the same.
2 lawsuits on the merits filed by Octagon, including a liability claim for €168 million in 2021 and 2023, never pursued, then an emergency request in April 2024. How would you describe the strategy emerging behind this timeline?
The only explanation we have is it's a strategy to cause harm and no other strategy. Because if you have a strategy to get money, if you file a lawsuit, you pursue it on the merits. And that is what they have never done. Meaning today, the basic idea was ultimately only to cause harm and never to go to the merits, because on the merits, there would be no chance, because there is no evidence that holds water in this lawsuit.
Grant Thornton was simultaneously a service provider, a tenant, and a member of the GCM board of directors. In hindsight, was this accumulation of roles a mistake?
With today's knowledge, trying to redo the past, that's something for fools. At that time, I thought it was a fantastic idea because I had a provider who was interested in my fund, who wanted to put money in, and who wanted to take on responsibility. For me, a dream to have a provider who wants more responsibility, more work, and a commitment that's not just material, but also economic. And at the time, for me, it was a good idea, and no regulator saw a problem in terms of conflict of interest. But as always, you only see the conflict of interest at the moment when there is a conflict. And that's where we are now.
You mentioned negotiation attempts that, in your view, looked more like blackmail. Can you be specific?
In 2021, indeed, Grant Thornton, Octogoni, were negotiating their early exit because, in fact, they were supposed to stay in the fund. It was from 2018 until 2026. And in 2021, they wanted to get out of the fund. And they tried to negotiate, but naturally these negotiations were held between lawyers, and so that is to say, confidential. Today I cannot speak because it was confidential between lawyers, but I can tell you the amounts that were requested smacked of blackmail. That's why I say it smacked of blackmail, because we can't disclose it since it was confidential. But today, the amount that was owed to them, it's not me who decided it, it's the central administration that does the calculation pro rata, based on what everyone invested. And if no one can have more than what the central administration calculates, except with the agreement of all the other shareholders, and there was no agreement to pay anyone more than what was owed to them. For the record, their investment of €800,000 was valued in 2021 at around €16 million, which was already a magnificent return between 2018 and 2021. It was already an absolutely extraordinary achievement. If we consider the fact that a typical real estate fund on average in Europe earns an annual return of approximately 6.5%. That is to say, from that perspective today, to ask for €168 million, it is just entirely and utterly ridiculous.
Octagon alleges facts that it describes as serious, punishable by criminal law. Why, in your opinion, did it choose this procedure rather than filing a criminal complaint?
I don't know why they didn't file a criminal complaint, but in any case, if you want to cause harm, you can always start a civil procedure because you can withdraw it at any time. A criminal complaint, once it's filed, it can no longer be withdrawn. And when an investigating judge gets involved in the case, he will conduct an investigation for and against the accused. And if you are afraid of yourself and what you have done, well, you're not going to go to criminal court because the investigation could turn against you. And that's why the reason that Octogone, Grant Thornton did not choose the path of the criminal complaint.